Everybody, I'm Bev Alfon. I'm a partner in the Amundsen Davis Labor and Employment Group. I'm joined here today with my partner, Jeff Risch. We are here today to discuss key regulations that are impacting the construction industry. There is a lot to cover, as you can imagine, so we're going to just jump right into it. One topic, let's start with something that's not specific to the construction industry. It's affecting all kinds of employers, well, most employers across the country. As of today, Washington, D.C. and 13 states have pay transparency laws in place, including Illinois, Minnesota, Vermont, and Massachusetts, and New Jersey, who all have pay transparency requirements going into effect in this year. Some have already gone into effect. They differ in their specific requirements, but generally they mirror transparency laws in California, Colorado, and New York. And most of these, of course, will require employers to disclose pay ranges and sometimes benefits information and compensation in the job postings. And of course, Illinois, New Jersey, and Massachusetts have an extra zinger in there, imposing requirements related to internal employees and notice requirements related to promotional opportunities for existing employees. So a lot of these newly effective laws and the ones going into effect have raised a lot of questions, right? If we're required to post pay scale and benefits, what exactly does that mean? Can I put a range down like $0 to $500,000? Do I have to give all the details about the various health plans we provide? Do I have to give the details on bonus compensation, something a lot of employers are going to consider to be business information they want to keep confidential, right? So most of these states have also they've issued guidance on these requirements in the form of FAQs and similar guidance. And I highlight these issues because really pay transparency and all these requirements are deceivingly simple in concept, but I think can be very tricky for employers, depending on circumstances, to comply with if you're not aware of things like what the enforcing agency is going to be considering in terms of compliance. For example, if the employer is required to post a salary range in good faith that they expect to pay the person they hire for that position, what information is that enforcing agency actually going to look at as good faith? Things can get even trickier when you consider that some states require, again, employers to notify existing employees about promotional opportunities shortly after posting the job, right? In general, these pay transparency laws really force you to consider what that's going to mean and the effect of that on the current employees as they are going to start seeing what you're offering to new employees, basically coming off the street. It can have an effect on morale, but I think, an equally important issue is, are you ready to have the conversations? Are you ready to have the communication with folks who are your existing employees to say, this is why this range looks this way, right? Keeping in mind, of course, when you're dealing with non-supervisory, non-managerial employees, they are generally free and clear to discuss their compensation with one another, right? That's protected by law. So are you prepared to point to the objective reasons why employee A is getting paid more than employee B, even though they hold the same position? Yes, in most of these cases, you can rely on things like experience, skill, and job location, but you'd better be ready to back up your position, right? You want to be able to rely on some sort of documentation about what those objective factors are. And then you also have to consider the type of candidate you are looking for. Who are you trying to pull in for that job position? You want to consider what you want to attract versus what you will attract, and that is also affecting employers in terms of the posted compensation range that they put on those postings. Sometimes that means internal adjustments need to be made. in terms of your existing employees. And then there are also requirements for some of these laws to basically not allow employers to hide behind third parties, right? You don't get to just say, well, I just gave the information to LinkedIn or to Indeed, and I'm going to hide behind a third party. It's not going to happen. Some of these laws have very specifically said the third parties are not going to be a shield for those employers. Instead, those third parties get to turn around and say to any enforcing agency, the employer didn't give us all the required info. So what are the to-dos, just generally about pay transparency, right? If you have employees in different states, be absolutely sure you understand whether or not there are requirements and what the specifics are related to pay transparency. Train your managers and your HR team regarding the new compliance requirements, because that's going to extend to job postings, promotional opportunity notice, and then of course there are also anti-retaliation protections tied to these laws. And then, as we discussed just a short while ago, consider how you're going to respond to inquiries about pay from job applicants and your existing employees, right? Evaluate your current compensation structure, and then review job postings for compliance. If you are leaving it to somebody else to take care of, every so often do a self-audit and make sure that your postings are actually in compliance, including those that have been provided to third parties. And then lastly, remind your supervisors and managers about all the related restrictions. Things like compensation history band, right, during the interview process. There are states that absolutely ban the question of what did you make. So that is certainly something that we need to make sure all employers have.
Just to throw a curveball,
Yeah.
this applies, these laws apply to both union and non-union contractors. What's somewhat of a curveball is the non-union contractor that's performing some prevailing wage work. Trying to get my head around it and what it all means, Beverly. I think that there needs to be at least some focus and some intentional focus on the range of pay may be more than what the base would be on the non-prevailing wage work. So just keep that in mind. It's a bit of a curveball. I've got a number of merit shop non-union contractors as clients, and they're sort of kind of putting their arms around this of if they do go out to do the job posting, and some don't do external job posting. There's no requirement or mandate that you do a job posting.
Yes.
But those that do job postings, just understand that if there is some prevailing wage considerations, we might want to think about language to help identify that possibility in addition to maybe a base non-prevailing wage rate.
Yeah, that's a great point, Jeff. I mean, I think that's parallel to even when we're going away from any sort of prevailing wage work, any type of language that you can throw in there, in addition to some base range, you want to be able to say, and that may vary depending on experience and skill, right? And location sometimes. Again, as long as we're able to explain where those differences may come, you should be in a good spot. Now, we're going to move on to some EEOC guidance. The U.S. Equal Employment Opportunity Commission issued some guidance in June of last year, really aimed at preventing harassment in the construction industry. So in it, they included 5 core principles that, I read it and I think, well, this is really very common sense, isn't it? It's really not very different than what we would advise some clients in principle in terms of trying to prevent workplace harassment. However, the EEOC stated that the purpose of this guidance was necessary. I mean, it really was necessary because workplace harassment remains prevalent in the construction industry, with some of the most egregious incidents of harassment it has investigated. That's their position. You'll see the first point is committed and engaged leadership. I think this really goes to collaboration. The EEOC is encouraging project owners and GCs to prioritize work site-wide collaboration, basically to make sure everybody's minding their P's and Q's in terms of preventing harassment. The second point, consistent and demonstrated accountability. I think it's just that. I think it is accountability. The guidance suggests that project owners and GCs consider requiring that contract bids include a written plan to prevent and address workplace harassment, right? It might just be that basically those bids require them to have a written anti-harassment policy, but then of course an accessible complaint system, and then regular training. Maybe they're just certifications. It's not a terrible idea, but it's one of the principles they're trying to push here to prevent the harassment again. And then number three, strong and comprehensive harassment policies. A lot of states require written policies as it is. It's not a bad idea to have it if you don't have that requirement. This certainly is an encouragement for the project owners and the GCs to make sure, again, that their contractors have a written policy. Number four, trusted and accessible complaint procedures. I think is probably the most controversial of these points because it really puts an onus on the general counsel, right? It says put policies and complaint procedures in writing and communicate them, and then goes on to say and suggest that the GC require the subcontractors to report all harassment complaints to the GC, particularly where there is alleged harassment of one subcontractor's employee by another subcontractor's employee. Jeff, would you ever suggest to a GC client to do this? To get involved? I mean, for me, I think there is a lot of concern there. I think if a GC goes beyond doing an administrative check, maybe to put some administrative burden on the contractors to report back if there are complaints, that's one thing. For the GC to get any more involved in that, I would probably have to push back on that simply because it can open the GC to some other potential claims, whether or not there be any base to it.
No, you require certain things from your contractor,
right?
And including evidence or the assertion of compliance, maybe attaching or committing to certain harassment policies and practices and complaint procedures. But yeah, there needs to be clear lines that differentiates who is the employer, who's in control of the workplace harassment or environment.
Right. So there is that, and I think that goes also for the fifth point here, which is regular interactive training tailored to the audience and the organization. That is an assurance I would seek from the contractors on training maybe, but I don't foresee that as a site-wide training. It just doesn't seem realistic to me. But we raise this here because although this guidance is not binding law, right, it doesn't have the force and effect of that. It certainly does tell us, though, what EEOC investigators will likely consider, when they're looking at what has occurred on a construction job site. Even though there may be some differences that are coming in terms of where the EEOC is leading and what their priorities are, we have to remember we're still dealing with the same investigators, right? So we thought it worthwhile to raise that here. Next, I'm going to go on to the NLRB, the National Labor Relations Board, Fair Choice Employee Voice Final Rule. And I know we chuckle about that name a bit because it's a bit of a misnomer. It went into effect on September 30th of last year. The final rule changed the rules at the NLRB in 3 different areas related to unions, okay? The first being employer recognition of unions in the construction industry. The second, blocking charge procedures. and the third, voluntary recognition bar. And we'll go through each one of those, starting with employer recognition. So this new rule that went into effect impacts the way that an 8F, so that's referring to Section 8F of the National Labor Relations Act, it impacts the way that 8F relationship can be transformed into a Section 9A relationship. So to really understand the effect of the final rule on employer recognition, we really have to dive in a little bit to understand the difference between an 8F and a 9A agreement. So what we have here is a chart to really put that contrast in place. So 8F agreements are considered pre-hire agreements, right? It means it's an agreement that an employer and a union have entered into before potentially any employees are even hired. It is a type of agreement that only exists in the construction industry. So essentially, an employer can enter into a collective bargaining agreement with a union even where there is no majority support for the union to be those employees' representatives. Congress gave this exception to construction in recognition of the nature of how the construction industry works, right? We have highs and lows that are seasonal. The workforce changes over pretty rapidly. That is why there is this exception. And an employer, and this is really the significant part of it, is an employer can unilaterally withdraw from the collective bargaining relationship at the expiration of the agreement, right? There's no bargaining required to exit the relationship when it is a Section 8F relationship. Contrast that to a 9A agreement. These are the sort of agreements that exist across all industries, including construction. So an employer enters that bargaining relationship either because it has voluntarily recognized the union as the representative of a majority of the employees that they seek to represent, or there is an NLRB, a board supervised election, that has resulted in that union being voted in by a majority of those employees who voted. Once that happens in a 9A relationship, then the employer must bargain in good faith with the union about the terms for a successor agreement. They do not get to, in other words, walk away from the union at expiration, right? 8F, walk away once the contract has expired. 9A, you got to sit down at the table and bargain about the next agreement. And the only way you're getting out of that, well, I don't want to get into all of that, but really an employer is required under 9A to maintain the terms of the existing collective bargaining agreement until a new one is reached or the parties reach an impasse. An impasse is really a term of art under labor law. There have to be all kinds of circumstances in place so that it's established, and then the employer can lawfully implement anything that they offered at the table, their last, best, and final, at that point. But they don't get to just walk away. And so that's really a key issue here when we talk about the conversion from an 8F agreement to a 9A. Okay, so a union can convert an 8F agreement to a 9A relationship either by winning an NLRB supervised election or demanding and obtaining the employer's voluntary recognition as the majority representative. So here's where the difference is. Under the old rule, when a union claimed to represent a majority of the employees and sought that recognition from an employer, they were required to have a contemporaneous showing of majority employee support for the union. In most cases, that referred to authorization cards, right? When the union starts to organize, they hand out the cards. Sometimes they have them do it online now, right? And that would be the proof that would have to be in front of the employer in order for that to, to support that demand for voluntary recognition. Under the new rule, language in the collective bargaining agreement is enough. As long as there is language in a written agreement between the union and the employer where the union says we've demanded and we've been recognized as the majority, as the representative for majority of the employees in this bargaining unit, period. That's enough. There's no need under the new rule to show any proof that the employees have actually supported the union. And then, of course, there is a 6-month limitation for challenging the union's majority status. So the bottom line here is we have to watch out for any reference to Section 9A of the Act or any acknowledgement that the union represents a majority of the employees or that employees have asked the union to represent them, right? Or if there is reference to a showing of majority support. So even if not true, under this rule, the board will only look at the language in the agreement. And the federal courts, who would be reviewing any of those board decisions, ultimately, are looking at contractual language versus actual evidence as well. So really beware of the language. That is the takeaway from this, no matter the title of the document. And we're going to get into this, but we all know there are union organizers who will show up with one sheet of paper. It looks very simple enough. But if you look closely, and they will tell you, by the way, that everybody signs this, if you look closely, it adopts all sort of agreements, including a master collective bargaining agreement, right? Or area agreement, as it's often called. And that area agreement often includes the Section 9A language. So it's incredibly important to be mindful about what you're signing. Sometimes these go by the name of participation agreements, right? And all of that. These are things that we absolutely need to be sure your company is not bound to if your intent is not to be in a 9A relationship. So a member of the board, Member Kaplan, dissented from the issuance of this final rule, right? He disagreed with the issuance of this final rule. President Trump just appointed him as the new chair of the labor board. But regardless, and I know there's a lot of politics tied to the labor board, regardless of where this turns, even if this rule changes, 9A language is something we should always, always be mindful for. Moving on to voluntary recognition bar. So the new rule restores what's called a voluntary recognition bar, and that applies when an employer agrees to a union's demand for recognition without an election. It basically removes the ability of the employees to petition for an election, right? To test whether or not, in fact, there is majority support. So once the employer recognizes the union, there is an immediate bar to any employee vote to test that claim from the union. And this is really significant because of the board's decision in CMEX Construction Materials, where it held that employers will commit an unfair labor practice if they fail to recognize a union based on a claim of majority support, unless within 14 days they file for an election petition. So what it does is it very much creates a default that requires the employer to recognize the union based on a claim of majority support without the secret ballot election.
It's a 9A.
Yes.
It creates the de facto 9A relationship, and just by process, just by this rule of law, really.
Right, and we've talked about this before. The 14-day period gives an employer almost no time to really gauge the situation, and then counter and campaign for itself in terms of a vote that would be coming for its employees. And then blocking charges have been reinstated under the new rule. And blocking charges typically were used and will be used by unions to block, to basically delay a decertification petition, right? A petition where employees gather, a majority of them decide we no longer want this union to represent us, and then they file a decertification petition. And now in this reinstated new rule, it's an old rule reinstated, the unions are able to file unfair labor practice charges to block the petition, basically delaying the ability of that petition to go forward until the ULP charge is fully investigated. So it's another way that this new rule is making it more difficult for the workforce to really choose to be without union representation once they're unionized. It's really where that is all important because it is what the standing rule is as of today. Jeff?
Yeah. So I'm going to talk. Thanks, Bev. I'm going to talk. I'm Jeff Risch. I help with the Labor and Employment Group here at Amundsen Davis, and I am going to talk about. It's a subject that I'm passionate about. I've been dealing with it for a while, and really started with prevailing wage mandates, federal and in Illinois specifically. Probably over 20 years ago. And then it's sort of avalanched into more apprenticeship mandates, more project labor agreements, and more responsible bidder requirements, which is, and we'll tackle each one at a time here. I want to start with the green energy and just miscellaneous government-related and backed incentives, typically financial incentives, even tax credit incentives. So certain states are more aggressive than others. We've got a federal government that's been, with the Inflation Reduction Act and the infrastructure legislation out of Washington, D.C. over the last 4 years, this has been front and center in the construction industry throughout the United States, and particularly in states such as California, New York, Illinois, New Jersey. You kind of get the list. So with that, as we're trying to compete, we need work. Understand that the Inflation Reduction Act, at least right now, is in place. We have prevailing wage and apprenticeship ratios that we have to identify. There's a lot of confusion and misunderstanding with these ratios and with the compliance. But when we talk about the Inflation Reduction Act, we're talking about Davis-Bacon prevailing wage, federal prevailing wage. This is not a state issue. This is a federal issue on the Inflation Reduction Act. I think we talked about the Inflation Reduction Act last year and probably the year before. And I don't want to I'm not going to dissect that law. What I want to focus on in this presentation this morning is the apprenticeship training, key points with the apprenticeship training to make sure that there's, some of these myths or misconceptions are addressed, and focus heavily on the prevailing wage Davis-Bacon and a reminder of what that means. So anytime we're dealing with an Inflation Reduction Act project or any project that is requiring apprenticeship training, please understand that, and this goes even beyond the Inflation Reduction Act, that the worker is considered an apprentice if the worker is employed pursuant to and individually that human being, that worker, is registered in a bona fide apprenticeship training program that is either directly through the U.S. Department of Labor or a state apprenticeship agency recognized and has a partnership with the Federal Department of Labor Office of Apprenticeship Training. And that's not all, the employer is adhering to the requirements of that particular program. Now, this is where a lot of contractors get into trouble. They don't know what program to follow. They don't even know what program, they don't even have a copy of the apprenticeship program that they need to adhere to. So this is not an exercise of learning as you go. That's not ideal. Though in my world, Beverly, I get a lot of contractors that are just signing up, get me the work, I need the work, and I understand we need work badly, but they're learning as they go, and they're stubbing their toe along the way. So just identify, for purposes of the discussion this morning, that worker that is considered and deemed to be an apprentice working on a construction site where apprenticeship ratios have to be met, certain apprenticeship ratios have to be met under the law, under the Inflation Reduction Act, or under local or state mandate, or under a private contract mandate or a CBA, understand that the underlying program and all the requirements of that underlying program must be adhered to and will dictate how we're going to manage that worker on the job site. Another, I think, key point with this is it may be possible to meet all of the apprenticeship requirements from one apprentice program, but if you have different trades involved in construction as the employer, as the contractor, you've got multiple trades involved, each trade, if there's an apprentice on that job site, has to be tied to an apprenticeship program for that individual trade. So if you have employees performing multiple trades, technically they would have to be involved with multiple apprenticeship programs, which is silly. It's just not possible. There's not enough time in the day. So be aware, be self-aware of the exact program for the exact type of work and trade engaged on the project. The other part of this is just prevailing wage, and some with key points with the apprentice. The apprenticeship program itself should specify the hourly rate for that apprentice. That's not something you're going to get from the U.S. Department of Labor. That's not something you're going to get from a state prevailing wage rate sheet. Sometimes it's the actual percentage, a percentage of the journey workers' hourly rate, depending on the years where they're in the apprenticeship program. It's tied maybe to 60%, 70%, 80% of the journey workers' prevailing wage rate. So understand that it's the program, the underlying program should define what that rate is. I've never come across a program that did not define and have a percentage or a fixed dollar, it's usually a percentage, for what that apprentice needs to be paid based in comparison to the journey worker. I suppose it's possible that it wouldn't address it, especially if a contractor has their own program and they didn't think to put it into their program that they have directly with the U.S. Department of Labor, because that's a possibility. I've not run across that scenario. But if you did, and it's not addressed in the program, that apprentice is going to have to be paid the full union scale or the full the full journey worker rate as probably tied to the prevailing wage rates for that job. Same thing with fringe benefits. Just a little note on the fringe benefits. The apprenticeship agreement can explicitly state the percentage applied to fringe benefits. Now, I don't see that. I've never come across an apprenticeship program that's defining a percentage of fringe benefits. It's the full boat. I have not come across that. So for hourly, and this is the bottom line with prevailing wage and apprenticeship training on job sites to be mindful of, and I think this is really key in what I'm seeing in 2024 and 2025. Understand that if you have an apprentice, it's out of your hands. You have to have an apprentice on the job or you have to be making efforts to have an apprentice on the job. And we'll talk a little bit more about that towards the end of the session here. But the bottom line is, understand what is the apprenticeship program, what does that apprenticeship program identify as the apprenticeship hourly rate for the work, and what does that apprenticeship program identify as any fringe benefit. It likely will not identify any sort of break on the fringe benefits, which means you have to pay the full fringe benefit for the apprentice for all hours worked. All right, moving on to Davis-Bacon final rule. I've presented this before, and I just want you all to understand and appreciate that there are certain mandates in the Davis-Bacon updated rule. Part of that mandate included certain transportation to and from a job site. As you may know or be aware, that was enjoined by a federal judge over the summer, so that's been put on the shelf. However, all the other components of this Davis-Bacon rule, Beverly, is the updated rule in October of 2023. That's still in place. And I don't see the Trump administration taking on the Davis-Bacon rule with any urgency. And even if they did, it's going to be, 2-3 years before anything is done, right? So the Davis-Bacon, just some highlights, some noteworthy highlights. Understand that it's really the prevailing wage rates are really now tied to the area-wide union CBA. Rates established in urban areas can be applied in rural areas where the rate data is deemed by the U.S. Department of Labor is not sufficient. U.S. Department of Labor may adopt local or state prevailing wage determinations. By the way, the state of Illinois has created a legislation that would require any federal prevailing wage job in Illinois to be tied to and adopt the state of Illinois prevailing wage rates. I don't think that's legal, but they can do whatever they want until a judge says they can't, right? I think that's kind of wild stuff. I can just see him talking in Springfield. Why not? Why not? We'll do whatever we want. I don't see how it's legal, but that's interesting. Automatic adjustments to rates based on the U.S. Bureau of Labor Statistics employment cost data, so the rates just keep going up and up and up. And they're looking at off-site fabrication, like a shop work, may be subject if you create adjacent to a prevailing wage job. And we're talking about Davis-Bacon, though I would suppose this would probably apply in prevailing wage states such as California, Illinois, New Jersey, where they have aggressive prevailing wage enforcement and laws. If you create a shop next to the job site, and the only thing that's being created in that shop is a material that's going to be used solely on that prevailing wage job next door, that's probably going to create problems for you. I have not run across that. A lot of the shop work and the prefabrication is being done at a brick and mortar location that's being used for multiple jobs, no matter where the jobs are located. But for those of you that are thinking, okay, we could cut some corners and do some sort of, some of the work, off-site fabrication adjacent to the job, solely for that prevailing wage job, that's going to be a problem under the new Davis-Bacon rule, as well as the aggressive states that have the aggressive prevailing wage laws and enforcement. Let's see. There's more slides here, and just for time, I'm not going to run through each one of these, but I've got on slide, I believe 101 and 102, we have a list of certain requirements, new requirements and mandates that clarify what is required and what encompasses some major points within the final rule. So word to the wise, please keep an eye, look at slide 101, 102. It kind of gives you an idea of awareness of what you need to have in mind as you're going forward and performing federal Davis-Bacon prevailing wage projects. I think the most important slide here with prevailing wage is the interplay with the local and state prevailing wage laws. Remember, state prevailing wage laws vary greatly. They're unique. They're not created equal. They all have their own little, quirks and nuances. And I say this probably once a week to a contractor or to a GC or owner or developer. You've got to identify what is required of that project. Prevailing wage is not created equally. There's changes, there's differences, federal versus state, Illinois versus California. What you think you know about prevailing wage on a federal level is not going to do you much good on a state level, and vice versa. So please understand, identify what is the project. The question that a lot of contractors are asking themselves these days is it federal prevailing wage or is it state prevailing wage? I have no idea. And then you start looking and I ask, okay, we got to look at the contracts. What does the contract say? What do the contracts say? And even the contracts from the owner, the developer, to the, this happens with private projects. If the government's involved, the Fed or the state, it's more clear, right? From the contract language. But when it's private development, and yes, private development can trigger prevailing wage obligations because that owner, that developer receives some sort of government financial assistance, whether it's some sort of incentive or a grant. Even tax credits now, especially with the green energy, there's a lot of these tax credits and renewable energy credits. So there's a lot of ways that private development now more and more is triggering not only prevailing wage obligations, but apprenticeship obligations. And so when I'm asking, the questions of is it federal prevailing wage or is it state prevailing wage, I usually get blank stares. And then I have to ask for the contracts. Let's look at the contracts. And when I see the contracts from the owner, developer to the GC, it's still not clear. There's references to prevailing wage, but it's not referencing the exact language that Davis-Bacon requires, or the exact language where the work is being performed, the state law requires. So it's still this, what is it? And, it's unfortunate, but it's something that as a contractor and as a GC and as an owner and as a developer, we should be asking the question, what prevailing wage applies? Is it federal? Then it's federal. If it's state, then it's one particular state. And so please have that in mind and understand that every project needs to be reviewed closely, and examined on its own as to what is required, apprenticeship, prevailing wage, etc., for that specific project, which is a good segue into, there could be project labor agreements that are required as well. So why don't you take it away?
Thank you. Yeah, just to echo what you're saying, Jeff, right? Project labor agreements are not all created equal either. I'm actually going to jump to the next slide. Let's just briefly talk about what a project labor agreement actually is, right? It's something that a governmental entity like a Department of Transportation, the state EPA, et cetera, imposes on all contractors for certain projects that would require all the contractors to comply with certain union collective bargaining agreements for certain trades on that public construction project. Companies basically have to agree to recognize the unions that are identified there as the representatives of the employees on that job. Use that union hiring hall, for example, to obtain most or all of the construction labor for that project, exclusively hire apprentices from the union programs follow the union work rules, pay into the union benefit funds, and then which really these non-union employees would probably not be able to access. So it in effect would force employers to pay double benefits, right? For example, if you're a non-union employer and you're already paying for group health insurance for your employees, and now you're on a job where you're required to also contribute for every hour they work to a union health and welfare fund, it's at an incredible cost for many contractors. So that is really what we're talking about here, right? So contractors are being told by the governmental entity, in order to receive the contract, you contractor must sign an agreement and agree to those union work terms and conditions. Basically a pre-hire agreement like we talked about, right? Where there's this agreement to abide by a collective bargaining agreement, even though the employees have not selected that union as a representative. I'm just going to go back here a second. So we note here that one of the ways to avoid penalties under the Inflation Reduction Act is if all the contractors on the project are signing a project labor agreement with all the applicable local trade unions. But of course, these PLAs are not all created equal because of the terms in those PLAs. There are differences, there are nuances in those agreements depending on the project, depending on who the letting entity is. And what really becomes interesting for us is when we start to deal with negotiation, right? And let's be clear, this is with regard to union and non-union employers, because the project that may be at issue in that project labor agreement may not be in the jurisdiction of what a unionized employer may have with a certain local union, right? Much like a non-union employer, of course, would be walking into those terms as well, in addition to whatever terms and conditions they already have in place. So there has to be, and it's really difficult, I think, in some cases, because those collective bargaining agreements are as different as every local union is. And the business manager and the business or agents that we deal with in order to negotiate. And you may say, well, what's there to negotiate, right? It's a project labor agreement. We have to sign on if we want the work. This is it, this is it. The problem for employers, non-union and unionized employers, is you then have to look at what that collective bargaining agreement really requires, right? There's no roadmap on how to navigate when we're talking about union dues. Is that union actually going to make us take money out of the pockets of our employees to send dues to a local they don't belong to, right? That's an issue. How will contributions to each of these union fringe benefit funds work, right? Am I supposed to do this for everyone? Am I supposed to do this for the pension? Do we want to be absolutely clear that if there are different start and end times within our workforce versus what's in the collective bargaining agreement, shouldn't we make sure there's agreement on that to not run afoul or to not give a union the excuse to potentially have a dispute with that contractor, right? What if the collective bargaining agreement requires payment to be done on a weekly basis, but we pay bi-weekly? Is that something we need to be concerned about? Maybe. Maybe there has to be a one-page agreement where there's some understanding of how that would work. And then equally important for a unionized employer who does not have an agreement with that local for that trade, how are we going to harmonize? My guys all come from, their home local is out here. I'm bringing them over into this town. This project requires me to follow the standards of that local. How are we going to harmonize the dues requirements, the fringe benefit requirements, and all of that? So like I said, those negotiations tend to get really interesting. And certainly we want to be sure as employers that we're going to protect ourselves from these contracts, and anything where there may be a discrepancy, there may be something that just isn't even covered. And largely with regard to the benefits, I think when it comes to that, we are often worried and concerned about the ability of those funds to come in later and audit the payroll books and records of the employers who contribute pursuant to a project labor agreement, right? Those audits cover wages and fringes. So we want to be sure, if there is agreement, that in fact fringes were supposed to go to one home locals funds versus the other. Let's make sure it's in writing. Let's try and avoid those kind of landmines from down the road. So we want to be careful about anything that is signed with the union. Again, as well, what does the PLA actually require? Does it require that we only comply with those standards? And if those standards, we better be clear on what standards we're going to be following, and that there is no language in anything signed relating to 9A and majority status, right? That we always want to be sure of.
And just to kind of move the things along as
Yeah.
a timing, Bev,
Yeah.
I would say that, the project labor agreement, don't be lulled into a false sense of security if you're a union contractor. You're signatory to a certain contract. I've got clients that are signatory to a wall-to-wall Teamster contract. They can do everything under the wall-to-wall Teamster contract. Doesn't do them any good on a PLA.
Right.
So they're finding themselves, hey, I'm union. I've been union for decades, and I can't do this work unless I sign a specific contract with the laborers, or the
Right.
operators.
Right.
That's baloney.
Yeah.
So please, this is not a union versus non-union. It affects everybody, and GCs need to be zeroed in on this with your contractors and your subs that you rely on. You might not. They may say, "I'm not touching it." So, just food for thought.
Yeah, absolutely. I mean, and that covers some of these main concerns, right? And Jeff just discussed how being union may not matter. It doesn't let you off the hook from some of the complications that may come from this. Again, with regard to the language, you want to be sure that signatory status you have with the union doesn't go beyond the project. And if it isn't absolutely clear, we better make sure it's clear before you start doing that work. There are also concerns related to pension withdrawal liability. I don't want to get too far into that, but basically if an employer starts contributing to a pension fund, right, it opens all kinds of cans of worms. And you want to be sure that, as an employer, you're not going to be looking at any potential liability. Some projects are long. Some projects go on for a while. Some projects have a lot of employees where contributions would be made to that pension fund. When those contributions stop, because the project is stopped, where is that going to leave you? Again, something you'll want to be sure you're clear about. And we already discussed the fund audits. We want to be sure wage and benefit terms are all crystal clear, especially where there may be some potential overlap. Private sector, project labor agreements, local government, I think we covered a lot of that. I'm going to just move on here because there are a lot of concerns. Jeff already touched on some of this, even with prevailing wage, like how is it that this even happens? We get those questions sometimes. We'll get clients from, Texas call us completely outraged, not understanding what all of this means, prevailing wage or the project labor agreements. And they say, how can this be legal, right? And sure enough, right, you may be saying, Bev, Jeff, what about Section 80 of the National Labor Relations Act? Maybe you're not saying that, but the rule generally, right, is that there cannot be agreements between employers and unions to agree to not deal with a certain company just because they've got a labor issue with them or a disagreement, right? Secondary boycotting. Can't do it. However, the NLRA specifically excludes these sort of agreements like project labor agreements. And then, and then this goes to the legality of it too. Some arguments for why PLAs may be illegal and why it would be important if there is going to be a PLA to show what its actual purpose is. This is really just covering some of what that discussion is. I'm going to turn this over to Jeff.
It's difficult to challenge a PLA. I mean, personally, but I'm not king of the land. I think a PLA that's mandated by the government is illegal. But, you know, I have no voice. You know, I'm just from the peanut gallery. I mean, how could they do that? You know, no, I think that's a lot of problems. But I'm not king of the land, and I don't think I'm going to be anytime soon. So they're here. Let's navigate them carefully. I think the bottom line, Beverly, if you're approached by a PLA, whether you're an owner, developer, contractor, GC, figure out what it means and what it means for that particular project. And for those subs, read everything with competent counsel before you sign. All right, responsible bidder, and just with the time that we have, I'm sorry. Responsible bidder. We're seeing more and more responsible bidder from the government, mostly from the government, sometimes with a developer or owner. They've got certain requirements, and these requirements make a lot of sense. The contractor performing work, and you can provide the customer, the developer, the owner, the GC, the upper tier contractor with satisfactory evidence that you comply with laws, that you pay and you will meet your prevailing wage obligations to the extent that they apply. You follow EEO laws. You're adequately insured. That's all common sense stuff. We're starting to see, again, participation in apprenticeship training programs tied to the USDOL or with a state agency tied with the USDOL, have an established office in certain localities. We're starting to see more and more of that creep up in these requirements. And then any other requirement that would be established. So when you see a responsible, this starts with the bid specifications. Before I ask for the contract, I ask, what did the bid require? What were the specifications for the bid? Right? What was asked of us? What was necessary in order to get our bid out there and get accepted? So there's a lot of different requirements, a lot of potential gotchas in this world. And so contractors and owners, developers, eyes wide open with respect to any sort of responsible bidder mandate. Typically, but not always, being handed down by the local government or state government. You want to do business here, you want to construct here, private sector and a lot of it's public sector work, public work. But even private development, your contractors have to meet certain requirements. We're seeing more and more of that. Apprenticeship mandate waivers. This is a big one. I saved it for the end because this is something I want you to take away. If you have a project and you need to have apprentices on the project, certain percentage, the union contractors will go to their local union and they'll say, hey, can I have an apprentice? And the local union will send them a letter saying, we don't have any apprentices to send. We would if we had them, but we don't have them. That's happening a lot, especially over the last few years. And then that will then give that union contractor the ability to get a waiver. Well, they don't get the waiver. The upper tier contractor, the owner, the developer, they get the waiver and everything is good. Everything's good. The non-union contractors should be seeking the same waivers from their third-party program sponsor. A lot of non-union contractors, if you're doing it on your own, if you got your own program, you're kind of SOL, right? You can't get a waiver. You can't waive yourself. It's your program. You better have apprentices. For the non-union contractor, maybe tied to Associated Builders and Contractors, I know that their organization has DOL apprenticeship programs. At least get it from the Associated Builders and Contractors or whoever the program sponsor is, and get the same letter from the program sponsor, similar to how the union contractors secure the same type of letter from the local union. And those waivers might not get approval till well into the project, so buyer beware. So we've got some takeaways here. Just from a time standpoint, I'm just going to hit the takeaways and then we can wrap this up. If you're not confused, you're not paying attention. Right? It's like the guy who would I was in law school with a guy who would take the law school exam. You got 4 hours to take the exam, and he's done in an hour and a half. He failed it. He didn't understand anything. So if you're not confused, you're not paying attention. Identify your legal obligations prior to bidding. If you bid without knowing the full scope, you're behind the 8 ball. You don't want to be behind the 8 ball. That's a bad thing. This is not a union versus non-union thing. There's multiple mandates, regardless of your signatory status, that you have to navigate. Review those bid specifications and all upper tier contractors that are always referenced in the bid and in your contract. Never assume private development is immune from it. Far from it, especially now, this day and age. This is a handy dandy slide. I'm not going to go through it because of time. 114, 7 basic rules for public works projects and government assisted projects. Just my 7 rules, and I think these 7 rules are pretty good. They're pretty good rules. And then finally, indemnity provision. This is just a handy dandy sample. Don't run with this. Bring it through your attorney. But this is something that if I was a contractor, lower or upper, and I'm entering into an agreement with somebody, I want some sort of indemnity with respect to what I'm not receiving, the information that I'm not getting. If there are mandates that have not been identified, and I do this work, or I go through this project, and there's problems, and those problems go back to the fact that you didn't inform me of those mandates, then I'm going to hold you responsible. You're going to make me whole because I didn't get proper notice. Anything else, Bev?
We're good.
We're good?
We're good.
All right.
Thank you.
So thanks, everybody, and I think we're back at 10:15. Great. Thank you.